Afternoon, everyone. As Mr. Sandile Chulai mentioned, my name is Nonkosazana Nkosi, and I'm a senior associate in the employment department here at Worksmans. So I'd like to park our discussion today on two fundamental tenets that I believe are critical to a strong and healthy democracy. The first, a robust public discourse that is founded on transparency. So we need to know what government is doing, and also accountability. We need to be free to engage meaningfully with government and also to hold them accountable for any decisions, any initiatives, or even the conduct of the state. Secondly, it's policies and laws that are responsive to our South African society. These policies and laws, in order to be responsive, need to be relevant to our social, political, and economic climate. They also need to embody our fundamental constitutional values of human dignity, the pursuit of equality, freedom, um, non-racialism, and non-sexism under the rule of law. And the reason why these tenets have been of particular interest to me is that I believe that they have been brought into sharp focus by the current developments within our employment equity space. There's been much debate regarding the relevance of affirmative action 29 years after democracy. And this speaks to the element of the relevance of these laws to our social, economic, and political climate. There's been questions on whether these employment equity interventions are a violation of the constitutional rights of non-designated persons. There's been questions on whether numerical targets are in fact quotas and actually represent a stark shift away from the aspirational goals of the Employment Equity Act. And of course, on the other hand, the Ministry of Employment and Labour has maintained that compliance and consequently progress in implementing Employment Equity Act, employment equity aspirations and objectives has been unsatisfactory and therefore necessitated more proactive measures, which could ensure the acceleration of societal and economic objectives. Before I delve into the substance of the amendments that have been proposed, I think it is important for us to agree on to have a universal understanding, at least, of what is constitutionally permissible when we're talking about employment, when we're talking about affirmative action. And I draw from the case of Barnard, where the court sets out that firstly, these targets must be aimed at persons who are subject to unfair discrimination, and that such beneficiaries of affirmative action must be actually suitably qualified in the sense that they should be equal to the task at hand. Why? Because we don't want to sacrifice efficiency and competence and lend to the dogmatic idea that affirmative action is nothing but a vehicle for mediocrity. And the court, I think, put it very succinctly that the object of equity in the workplace is to employ and retain people who not only enhance diversity, but who are also competent and effective in delivering goods and services. Now that we're moving from at least an understanding of what affirmative action is, I think it is also important to then discuss, well, what is the difference between what we have now and what is proposed? And I think it boils down to the element of agency. Currently, employers are free to go and identify barriers and then decide what measures are we going to put in place to ensure that we eradicate barriers to employment. And the government has really been involved to just simply ensure that you are identifying barriers as employers, and also to hold you accountable to any measures that you're actually implementing. And as I've noted before, the ministry has decided that this is just simply not working. We need firmer measures. Hence, we're ushering in a new dispensation. And it seems in this new dispensation, the ministry has, to a very limited extent, ring-fenced for itself the ability to identify employment barriers and also to then prescribe, again, to a very limited extent, how to address and eradicate these barriers. And it has done so by confining itself to numerical targets. Numerical targets are not a new phenomenon. Section 15, subsection 3 envisages numerical goals. So we're still very much within the confines of the Act when we discuss this. And the reason why I say it's to a limited extent is because employers still have the obligation to identify barriers to employment. This is still very much relevant, and you still have to come up with measures on how to eradicate those barriers. For example, an employer can conduct an analysis and discover that we don't have enough facilities that accommodate people with disabilities, and come up with measures for these. An employer can decide, well, the way we grade our jobs is problematic because we don't fully embrace the principle of equal work for equal pay. So it seems like the arrangement is very much a cooperative one that this new dispensation is trying to usher in. Now, let's get to this element of what government has confined for itself, which is numerical targets. Section 15A of the proposed amendments bestows on the minister the power to set numerical targets for national economic sectors. This power does have built-in checks and balances, and the first one being to consult with the National Minimum Wage Commission. And the National Minimum Wage Commission is constituted of various stakeholders, including independent experts, organized business, labor, and community. The second checks and balance is that the minister then has to publish these proposed numerical targets for comment. So, do numerical targets apply to you? I think it's important that employers know this so that they can prepare themselves. Government has said that the first compliance year will probably be 2024. And so, as I've discussed, the first thing is that you need to be part of the identified national economic sectors. The net has been cast very far and wide in this respect. There are 18 national economic sectors that have been identified and are quite broad. They range from agriculture, forestry and fishing, information and communications, and even reach as far as the arts, entertainment, and recreation. So the real limitation, I think, to whether or not numerical targets will apply to employers is whether or not the employer is defined as a designated employer or a non-designated employer. Designated employers are employers who employ employees that are 50 and above. This is not a new limitation. It has been there in the Act. The only difference is that employers who employed employees who were below 50 would only be regarded as designated employers if they had annual turnovers that were breaching certain thresholds under Schedule 4 of the Act. The proposed numerical targets have been published by the ministry. This was on 12 May 2023. And at this point, they are percentages that are applied over a 5-year period to the 18 identified national economic sectors. The targets are divided in terms of population groups and gender groups. And the population group is then further subdivided into 4 racial categories, that being African, colored, Indian, and white. Then the gender group being divided into male and female. These population and gender groups are then arranged in terms of national targets and provincial targets. It seems from the explanatory note to the regulations that employers will have the option to elect whether they want national targets to apply to them or provincial targets to apply to them. So it may be useful to start considering which targets may allow your business a little bit of flexibility when implementation hits. Now, the targets are also further divided into occupational levels. These are top management, senior management, um, professionally qualified, and skilled occupational levels. But there's also built-in protections for persons with disabilities. A caution here, it seems the explanatory note hints that if an employer conducts an assessment within their workspace and discovers that there's underrepresentation for semi-skilled and unskilled workers, the targets that you select, whether national or provincial, will also have to be applied to these levels. The question then, are numerical targets flexible? We do have a guideline in terms of Barnard. The idea is that quotas act as job reservation mechanisms. So if I need 5% of a category of designated people, then I hold that 5% and I only ensure that I'm appointing those people. That would be a quota. But if we are being flexible, we set up goals to ensure representativity and equity. That 5% in this case would be, I need 5%, that my aspiration is to ensure that I have 5% of a particular category. However, if there's no one who's qualified, if there's no one who's skilled or experienced in that area, then I ought to be open to appointing someone who is equally qualified from a non-designated group. It seems that the ministry has been considering how to build in flexibility to this particular system. On the 21st of September 2018, the proposed amendments to the current 2014 regulations were published. And part of this, the minister proposed Regulation 7A, which is a criteria that the minister would consider when setting up targets. And this criteria includes considering qualifications, skills, and experience within a sector, the capacity to acquire within a reasonable time the ability to do the job, the rate of turnover and natural attrition within that sector, and recruitment and promotional trends within the sector. A further attempt to build flexibility in the scheme is under Regulation 16.4A of the 2018 regulations. These set out specifically the grounds for that employers can raise whenever there's cases of non-compliance with the numerical targets. These include insufficient recruitment and promotion opportunities, insufficient target individuals from the designated groups with the relevant qualifications, skills, and experience, court orders, transfer of business, or even mergers that affect the demographics and representativity of the business, and also any financial or any economic feasibility considerations would be built into this. So it is our understanding that these flexibilities allow employers within their employment equity plans to actually incrementally build towards compliance, and to also think about, well, how do I ensure that I also build in defenses that are credible and justified for why I have not been able to comply within a 5-year period. This leads us to, I believe, what is the most controversial section, Section 53, contracting with the state. This section is not new. It has always been in the Act. However, it was not promulgated. And government wanted to give employers a chance to get their houses in order and build up capacity to compliance before it was promulgated. So just briefly, the Section 53 as it currently stands, non-designated employers would qualify for a compliance certificate, which would allow them to contract with the state in circumstances where they demonstrated that they complied with the prohibition on unfair discrimination under the Act. And then designated employers would also be entitled to receive the compliance certificate where they could demonstrate both a compliance with the prohibition of unfair discrimination and also compliance with affirmative action measures under the Act. Now, Section 53.6 introduces some changes to this regime. So the minister here can issue a compliance certificate where there is compliance with numerical targets. However, remember, there are justifications that employers can bring to say there are reasons why I have not complied with the targets. The minister will also assess whether the annual reports that have to be submitted to the Director General have been complied with. Are there any awards or orders that relate to a violation of the prohibition of unfair discrimination provisions in the Act? Do you have any awards or orders that also constitute a violation of the National Minimum Wage Act? What is interesting in these changes, firstly, is it appears that the factors are conjunctive. So it remains to be seen how the ministry is going to apply this, especially in circumstances where, for example, an employer has awards that against them of a violation of the prohibition of unfair discrimination provisions, but they are reviewing them. It remains to be seen how that will be done. And also another element of caution is that this new proposal brings in non-designated employers who seek to do business with the state. They will have to comply with numerical targets. Then we move on to the question, the employment question. Can an employer say, oh, I need to comply with numerical targets, so I'm going to impose a moratorium for the next 3 years and only appoint designated persons, or I'm going to make space, and so I need to get rid of a couple of people so that I can ensure that I comply with my numerical targets? Absolutely not. That is not allowed. One, we need to respect the rights, the constitutional rights of non-designated persons to their human dignity, to fair labor practices, freedom of trade, occupation, and profession. The Labor Relations Act would also be something to contend with because it has carved out for us clearly when dismissals may occur. And most importantly, the Labor Court has been very clear that affirmative action is not a justifiable ground for retrenchment. Further, you have the Employment Equity Act, which will be a barrier. Again, Section 15.4 is clear that no barriers may be created in the application of affirmative action measures that will impact non-designated persons' ability either for prospective or current employment and even their advancement. Then there's Section 15.2b, which requires that when you apply affirmative action measures, you ensure that you respect, that you allot to people equal dignity and you respect all persons. The most recent development is the settlement agreement that was signed by the Ministry and Solidarity. This was done on the 28th of June 2023. It really arose out of a complaint that was lodged on the 21st, in 2021, to the International Labour Organization. And this had to do with a violation of Convention 111 of 1958. So the question that we want to just consider here is really what has changed. And our answer is that substantively not much. What the settlement agreement, I think, does is to simply consolidate what has been in the draft regulations and in the Act and concisely put it for us in a manner that every layperson can get. And so let's look at some of the undertakings in this settlement agreement. The first one is that affirmative action is of a temporary nature. Agreed. However, it is temporary in the sense that once transformative goals under the Employment Equity Act have been attained, it would be difficult to justify the continued application of restitutionary measures that are not rationally supported nor related to the Act. The second being applying affirmative action in a nuanced way that is already happening under the Employment Equity Act. The no absolute barrier provision is under Section 15.4. The factors that are applied for the employment equity plans, reports, and compliance assessments are just reiterations of the reasonable grounds, which in any case employers can raise as defenses for if they want a compliance certificate under Section 53, so they want to do business with the state, or where the Director General is assessing compliance with the Employment Equity Act under Section 42, subsection 4. Lastly, the pronunciations on no penalties and no termination of employment. We've touched on this already, but what I'd like maybe as a parting shot to say is that the employment equity plan cannot be applied beyond the existing lawful limits, nor can it be enforced beyond the existing lawful limits. So our answer is that the settlement agreement really just succinctly puts into one place everything that government has communicated as its intention. In closing, I'd like to borrow from the words of Justice Pius Langa in his thoughts on transformative constitutionalism. And he states that transformation is not something that occurs only in courtrooms, parliaments, and governmental departments, but it really is indispensable to our society. And I think we will be safe if we heed and keep to the cautions of the Constitutional Court in Barnard, where the court mentioned that measures that are directed at remedying the past discrimination must be formulated with due care, not to invade unduly the dignity of all concerned. We must remain vigilant that remedial measures under the Constitution are not an end in themselves. They are not meant to be punitive or retaliatory. Their ultimate goal is to urge us on towards a more equal and fair society. And that hopefully is a non-racial, non-sexist, and socially inclusive society. Thank you.